Hello, my name is Rick Gash, and I wanted to spend some time with you to explain what happens at your Social Security disability hearing and what to expect. I've been handling cases now for about 30 years, actually a little over 30 years, and I've seen a lot of different judges, a lot of different situations, but the hearings have a few things in common, and I wanted to go over those things with you today to get you ready for your hearing. First thing I wanted to tell you is that the hearing is extremely informal. It is more like a meeting than a hearing. There's not even an attorney there representing Social Security. The hearing is what we call a non-adversarial uh, proceeding, which means that you will not be cross-examined by an attorney for SSA. Most judges are very nice and they will treat you respectfully. The judges are, as a general rule, looking for ways to improve your case when they can. Just remember that the hearing is actually your opportunity to tell Social Security why you're not able to work. So there's some important ground rules that I'd like to talk about before I get into everything about the hearing. First thing is obviously to always be respectful to the judge. A judge that dislikes you will usually rule against you. So don't give the judge any reasons to dislike you. And some of the things that judges don't like is vague answers or answers that seem like you're not really telling the truth. You're trying to maybe skirt around the issue. It's just important to just be respectful to the judge and answer their questions. If you don't know an answer to a question, it's okay to say, I don't know. No, we might ask you to give us an estimate, or if you don't know for sure. This usually happens with dates. Most people can't remember exact dates, especially when it comes to their employment. So understand that if you don't know the exact information, it's okay to tell the judge that, and the judge will know that you're guessing or estimating. If you don't understand a question, it's okay to say, I don't understand. I will explain the question to you so that you do understand it. We don't want you answering any questions that you don't understand. If we ask you a yes or no question, it's really important for you to answer yes or no. You can't say or shake your head. So the audio portion of the hearing is actually being recorded, so you have to speak verbally. The other thing I'll tell you is just be loud. Make sure the judge can hear you. If the judge can't hear you, again, it goes back to being respectful to the judge. The judge definitely will have a problem if they have to constantly ask you to speak up. Don't feel like you need to explain your answers. If we ask you a question, just answer it. Don't be defensive about the question, just answer it as best you can. Don't exaggerate or minimize your answers. So playing down your answers sometimes can hurt your case. So don't tell the judge that you can lift 50 pounds when you can only lift 10. We're here to tell the judge why you're not able to work, and so it's important to give the judge accurate answers to the questions that we ask you. And of course, the last thing is to just always tell the truth. So I wanted to talk about who will be participating at your hearing. Of course, you will be there. You're the claimant. As your representative will be there representing you. Another person present will be a vocational expert, also known as a the judge. We also call the judge an ALJ, which stands for Administrative Law Judge. The other person present is a hearing monitor. This person is responsible for setting up the phone, the video conference, whatever it is, and they also record the audio portion of the hearing for the judge. So a little bit of housekeeping. The first thing that the judge will ask you, in fact, the judge will ask the VE this question and also myself, if you are alone and if you are not recording the hearing. The judge wants to maintain your privacy and ensure that nobody else is there helping you with your testimony. So during the hearing, it's not okay to have someone there present with you, overhearing everything, trying to assist you. It's not okay to have somebody text you or email you. It's not okay for you to text me during the hearing. In fact, I will have my message app turned off during the hearing. The next thing that will happen is the judge will ask you to take an oath to tell the truth. You'll simply raise your right hand, and the judge will ask you if you swear to tell the truth, and then you'll say yes. After the judge swears you in, typically the judge comes to the representative with some questions about the evidence in the case. The judge will review all of the evidence in the file, ask if it's up to date and if there's an objection to anything in the file. The next thing will happen is the judge will, the representative will, so after the judge asks about the evidence, the judge will ask the representative if there's any outstanding evidence that we are waiting on that we just could not get before the hearing. This typically doesn't happen, but there are situations where because of a problem with a provider or something that happened, we can't get the records for whatever reason. So it's important that we let the judge know, and the judge will hold the record open for that. And then the judge will ask me if I want to make an opening statement. I don't always make an opening statement. I feel like it's not necessary. I don't want to kind of show the judge our cards before the hearing even starts. But if there are any issues that need to be discussed, I will typically address those in an opening statement. So the judge will now go to your testimony. And your testimony, basically, there's 4 phases of questions that the judge is going to ask you at the hearing. The judge will start out, number 1, with background questions. The judge will then go to questions about your past work. Then the third thing is the judge will ask questions about your medical conditions. And the judge will then ask you questions about your limitations. Now, keep in mind that some judges will ask all of the questions. Some judges don't ask any questions. They'll want the representative to go through all the questions with you. I would say 90% of the judges that we see will just start out with the background questions and do the past work, and then they'll turn it over to the representative to discuss the medical conditions and your limitations. So with background questions, the first thing I wanted to explain is why these questions are important. These help the judge identify you, make sure you are who you say you are, determine your educational experience, and it gives the judge some background information about your situation since you became disabled. Your education is important because the judge will make a determination later on about whether you're able to do other jobs. So that's why they ask those questions. So the judge will ask you for your full name, your mailing address, your social security number, date of birth, and probably ask you how old you are. The judge will then ask you about your educational experience, how far you went in school, did you graduate? If you didn't graduate, did you get a GED? If you didn't get a GED, did you attempt to get it? If you have any degrees, any certifications or licenses, either now or in the past, the judge will also want to know about those as well. The judge will ask you about your marital status and your current living situation. The judge needs to know who you live with, if you have any pets, just to get an idea of what's going on at home. I think a lot of times they do this to see if you're babysitting grandchildren or you're watching children or doing something else, and they just need to get an idea of what's going on at home. It might not seem important, and it probably isn't, but the judge is normally going to ask those questions. The judge will ask you for your height, your weight, and whether you're right-handed or left-handed. The judge will also ask if you are receiving any type of assistance like food stamps, housing assistance, or any other benefits like veterans disability benefits if you're a veteran, long-term disability benefits, anything else that the judge would want to know about. So then the judge will ask questions about your past work. Now, why are these important? Well, the judge needs to know about your past work so the judge can determine whether you can still do any of these jobs. It also helps the judge understand whether you acquired any skills that can be used in other jobs. In other words, if you worked in construction your whole life, so you may have some skills that you've acquired from doing it so long that would enable you to do a supervisory type job, those things. So there's a reason the judge is asking these questions. Now, the questions about your past work are only for the period of the 5 years before you stopped working. Anything past 5 years after you stopped working or after you became disabled, the judge doesn't need to know about. So the judge for each job is going to want to know what was your job title, who did you work for, what is the heaviest amount of weight you lifted at the job. And the judge is going to want to know in pounds. So, you need to tell the judge specifically what the amount was that you lifted. The judge will want to know if if you had to stand or walk more than 50% of the workday. If you had a job where you didn't do any lifting, but you had to walk around or stand for at least 50% of the day, it moves your past work exertion level to a different level, to a higher level. So that's why it's important. Did you supervise other people? And then the judge is going to want to know why you left the job. So supervising other people, doing reports just helps the judge understand what skill level your job was. And then it's always helpful if the judge gets a little bit of an idea of why you left the job, especially the last job that you did. Most of the times that's going to be because of an impairment and because of a condition that you have that is keeping you from working. You can also go ahead and tell the judge about any problems you were having before you quit working. So in other words, say you quit working on February 1st, but for the 6 months prior to that, you were missing a lot of work and your employer was kind of putting up with it, hoping it would get better, but it didn't. The judge needs to know about that. The judge will want to know if you were let go or if you left employment on your own. Okay, the next series of questions will deal with your medical conditions. And we'll start out first with the physical conditions, and then we'll talk about any mental conditions related to your disability. These questions are important because it helps a judge understand your conditions and how they affect you. The judge will have a really good knowledge of your medical records. We'll have reviewed those records and know a lot about your condition going in. And the judge will be looking for things that you tell the judge that they also see in the records. So typically, the judge will want to know what part of your body is affected. For example, if it's a low back injury, you would say it's my low back. What symptoms do you experience? What activities do you do that make it worse? For example, if you have that back injury, if sitting or standing for long periods would hurt your condition, then that would make it worse. If you lifted more than, say, a gallon of milk, that might hurt your back and make it worse. So think of things that you can tell the judge that you do that would make the condition worse. What makes it better? Now, here we're talking about things like the need to lay down, hot packs, cold packs, whatever you do to help feel better during the course of the day. We need to let the judge know about that. Now, obviously, if you're taking medications that might help you feel better, but that's not what we're referring to here. We'll talk about that soon, which is the next series of questions. The judge will ask you what medications you take for the condition, and then if you have any side effects from your medications. And here, the judge is just looking for any side effects that you experience. And of course, the judge is going to be looking to see whether you reported those side effects to your doctor. But if you are experiencing side effects, we need to let the judge know if certain pills make you drowsy, if they make you feel ill, or if they cause problems with your stomach. Whatever it is, just let the judge know what's going on with those medications. And then this is important. If the doctor verbally told you not to lift more than, say, 10 pounds or gave you any type of restrictions, either verbally or in writing, let the judge know about that. That will help the judge tremendously. Okay, the next questions deal with your limitations, and let's talk about those real quick. So why are these questions important? The judge needs to understand how your conditions interfere with your ability to work. This gives you a chance or an opportunity to provide real life examples to help the judge understand your condition and why it keeps you from working. For example, the judge might ask you, how much can you lift? And here you want to answer in pounds. Just to give you a frame of reference, a gallon of milk weighs 8 pounds. A concrete cement block weighs about 35 pounds. So what I want you to think about is how much could you lift in the work setting, and if you had to lift it, say, for 3 hours in an 8-hour day, maybe not 3 hours straight, but a total of 3 hours out of an 8-hour day. How long can you sit? And think about like an office type chair, and we want to know how long you can sit in minutes. answering the judge with answers like not very long, judge, or just a little bit, that doesn't help the judge because they don't know what that means to you. So be specific, answer the question in minutes. So if you can only sit, say, in an office type chair for about 15 minutes and then you need to get up because you have pain, let the judge know that. How long can you stand in a stationary position? Again, this is in minutes. We're talking about standing, not moving around, like at a workbench. Let's say you had to stand at a bench and say put parts together or do some other type of job standing. Just need to know how long you could stand. How far can you walk before you need to take a break? So if you're having trouble walking, so typically we want to answer that in feet. You can say maybe in minutes if that's helpful, or in blocks. Just don't say not very far, or don't say out to my mailbox. That doesn't help the judge. We need to know specifically how much you can or can't, or how far you can. Describe any problems that you have with reaching, handling, or fingering. So reaching would be in front of you or up above, like say reaching to get something out of a cabinet. Handling deals with holding on to objects like a cup or a glass. If you're having problems holding on to things due to your condition, maybe you drop things, maybe it hurts if you do it for a long period of time. And then fingering is fine manipulation. That's where you're manipulating fine objects like, say, small screws or bolts or coins or just something small, typing on a keyboard, typing or using your smartphone. Those are examples of things that you need fine manipulation for. A lot of jobs require you to be able to handle and finger at least more than 3 hours out of an 8-hour day. So maybe you could do it for 15 or 20 minutes, but if you did it for a prolonged period of time, maybe after 3 hours, you wouldn't be able to do it any longer. Now, do you need any breaks during the day to lay down? Are you having pain symptoms? Do your medications make you drowsy so that you need to lay down? That's important because obviously if you're at a job, you would not be able to take a break and lay down. The judge would want to know how often this happens. Does it happen once or twice a day? Does it happen once or twice a week? And then when you do lay down, how long do you lay down for? That's really important. Is it 20 minutes? Is it 2 hours? Is it all day? And this next question is one of the most important questions that I'm going to ask you at the hearing because it goes to whether or not you would be able to show up for work every day. So the question is, do you ever have days when you can't get out of bed or you need to lay down more than 50% of the day? So maybe you tried to do something the day before and you're paying for it now, and so you're down for the next 2 days. You can't get out of bed, so you spend most, if not all, the daytime hours in bed. Or maybe you just need to be in a recliner with heating pad or ice packs or whatever it is. Even if you don't do something to aggravate your condition, it just happens on its own, and you have pain, and so you need to go lay down or rest for most of the day. And so we need to know how many days per month that happens, and we would usually ask you how many days out of 30-day month. So if it's 15 days a month, is it 1 day a month, is it 2 days a month? The reason this is important is, like I said, we'll ask the vocational expert later on if there are any jobs that would allow someone to be absent from work more than, say, 2 days per month. And I can tell you what the answer is. There are none. So this is why we ask these questions. Do you ever need assistance with bathing, dressing, or caring for yourself? So do you need help with any of those things? If you're having problems with your hands or fingers, maybe you need help buttoning your shirt or your blouse, or maybe you need assistance in the bathroom, maybe you need help in the shower. Whatever it is, we need to let the judge know about that. And then one of the things I forgot to mention back to walking, if you need to use an assistive device like a cane or a walker or a wheelchair, we need to know about that, obviously. And we need to know when you need to use it, what situations, do you need to use it just when you go out, or do you use it around the house, things like that. The other thing the judge will want to know is whether or not that assistive device was prescribed by your doctor. Some additional questions are, can you prepare a meal for yourself? Most people are going to answer yes, that they'd be able to, say, fix a sandwich or a microwave meal. However, they might not be able to make a full meal for their family, something that takes an hour or longer to prepare. And if they do, or if you do, make sure you mention that you need to take breaks. You can only do it for 15 or 20 minutes, then you have to sit down for 15 or 20 minutes. Examples, everyday examples really help the judge understand. Are you able to go grocery shopping at the grocery store by yourself? So do you do you go by yourself, or do you need help, or do you don't go at all? The judge will typically ask this question because it's a real life example that tells him whether or not you're able to lift or carry groceries. So, nowadays we get a lot of clients that will say they just do their Walmart orders or have their orders delivered to them, or maybe their spouse or one of their children does all the shopping for them, or does all the carrying, whatever it is. Can you do laundry? And this is a good one because the judge wants to know if you can, say, for example, lift the wet clothes out of a washing machine and put it into a dryer, which for a lot of people they're not going to be able to do. Maybe you're able to do some of the folding, and it's okay to tell the judge that. Can you do outside yard work? You mow the lawn? These are important questions because if you're able to mow the lawn, and let's say it takes you 2 hours to do it, the judge is probably not going to think that you have a major physical problem that keeps you from working. So during this part of the questioning, we'd like you to give the judge as many real life examples as possible. So if you're having particular problems with certain things during the course of your day, I have clients that will say they can't open a jar because of their hands. I have clients say that they can't even climb a flight of stairs. Clients will say that they used to golf, or they used to do some other form of sporting events, or they had another hobby that they could do that they can't do anymore. Maybe you don't go to church anymore, don't go out with friends. Whatever it is that you are not able to do, those real life examples can help the judge understand your physical and mental problems. Now, we're going to talk to you about the questions on the mental part of your case. And these questions are important because it helps the judge understand how your mental impairments affect your ability to work. So what symptoms do you have that are related to your mental condition? So if you are anxious, do you have panic attacks? If you're depressed, do you have crying? Do you have tiredness? Do you have trouble concentrating? Do you have problems focusing? Whatever, racing thoughts. There's all types of symptoms that go along with depression and anxiety and other mental health conditions like post-traumatic stress disorder. And there's a number of them. So let the judge know what symptoms you have. The judge is going to want to know how often you experience these symptoms and what does it feel like. So do you have them, every day, 3 or 4 times a day? Or do they last all day long? Do you only have it every now and then? Is it 5 days out of the month where you, for whatever reason, your condition is bad and so you're in bed all day because of it? So let the judge know how often you experience it, what it feels like, and when you do have these situations, if they last all day, let the judge know. But if it's something that lasts for 15 to 20 minutes, or if it lasts for longer, we need to let the judge know. We also need to know when those situations arise, would you need to take a break from your job and maybe go to the break room or go to your car or whatever you need to do to alleviate those symptoms if possible. What causes or triggers your symptoms? And this typically is with when you have an anxiety condition or panic attacks, if you're in crowds or around a lot of people. Maybe loud noises bother you, stress, whatever causes or triggers your symptoms. Please think of those and let the judge know what they are. And I kind of touched on this earlier, but does it interfere with your ability to complete tasks? Do you have a problem focusing? Do you have a problem remembering things? How do you cope with your symptoms? So clients will tell me a lot of times that they isolate themselves in their own room just so they can cope. If they're around people, even if they're around family members, they become moody or they have issues or problems that are associated with their condition. We have clients that unfortunately will abuse alcohol or abuse drugs because of that. So if that's something that is happening, let the judge know that. It's better to let the judge know that the reason you do that is because of your conditions. It's a way you cope with it. If you're not getting along with other people or having difficulty being around crowds, those types of things help the judge as well. So think about everyday types of things that might interfere with your ability to work. So that'll be all the questions for you at the hearing. The next part, and this is the final part of the hearing, is the vocational expert will provide some testimony for the judge. Now, the vocational expert is really there to do two things. The first thing the VE will do is classify your work according to the dictionary of occupational titles. We call this the DOT. So you'll hear us say the DOT. You'll know what that means. The vocational expert will tell the judge about your past work, whether it was a heavy job, a medium job, a light job, or what we call a sedentary job. So a heavy job is any job that requires you to lift 50 pounds or more, even if it's one time. A medium job is between 25 and 50. A light job is lifting up to 20 pounds, and a sedentary job is never lifting more than 10 pounds, but sitting. And to do a sedentary job, you need to sit for at least 6 hours out of an 8-hour day. Remember, I mentioned earlier that if you, in your past work, didn't do any lifting, but you were standing all day or more than 50% of the day, even though you didn't do any lifting, that would be considered a light work. The second thing the VE will testify concerning your past work is the skill level. So there's 3 categories. It's skilled, semi-skilled, and unskilled. And you'll hear the vocational expert say SVP 2 or SVP 9. It's a rating scale from 1 to 9, 1 being unskilled, 9 being skilled. SVP stands for specific vocational preparation. And it's just a term that the vocational expert will use that they take from the DOT. So this is why we asked those questions earlier about whether or not you supervised other employees, if you were a lead worker, if you had to do reports, those types of things. The second thing that the judge is going to do, the second thing that the VE will do is answer some hypothetical questions from the judge. And just keep in mind, during this part of the hearing, it will sound like the judge thinks that you can work. It might even sound like the vocational expert is saying that you can work, because the judge is going to ask some hypotheticals where the vocational expert will be able to identify jobs that a person within that hypothetical set of facts can do. That doesn't mean that the judge or the vocational expert thinks that you can do that job. It just means under that set of facts, that hypothetical person could do the jobs that the vocational expert testifies to. Keep in mind that the judge is going to ask more than one hypothetical, and so there will be hypotheticals that the vocational expert will answer saying that there are jobs that that hypothetical person could do. So just don't react to that. Don't get upset if that happens. It's just best to just leave this. Don't say anything during this part of the hearing. The judge doesn't want you to interrupt the vocational testimony, doesn't want you to interject that, no, you can't do this or I can't do that. Again, it's hypothetical. So just let this part go. I'll deal with it. I will get an opportunity to cross-examine the vocational expert and provide my own hypotheticals. And again, I can't stress enough how important it is that you not say anything during the VE's testimony. When the hearing is over, I will call you and we'll answer any questions that you have about really any part of the hearing, but most of the questions I get deal with the VE testimony. So the final part of the hearing is just the conclusion of the hearing. The judge will then explain the decision process and close the hearing, tell you that a written decision will be issued. Typically, we get that in 30 to 60 days. And that if you have any questions, to call your representative. Of course, like I mentioned earlier, we will call you and answer any questions that you have about the hearing when the hearing is over. So that's it in a nutshell. It's very laid back. The hearings are very informal. They are really your chance to tell the judge in person, either by phone, video, or in person, why you're not able to work.